Always nice to see real estate expert Shay duPont, and she's back with us from the law office of Morris duPont to tackle another hot real estate topic. And today we're talking about defending a foreclosure action against your property. When and why, and is it worth it? Those are my three questions.
Those are very good questions. When you have a foreclosure action filed against you, that alone is an interesting question, because a lot of people think that when the lender sends them a notice of default or a notice of acceleration saying, look, we're not going to accept any more payments from you, you're in foreclosure. Well, you're not really in foreclosure. Foreclosure is really defined as a civil lawsuit being filed against you by your lender. They're the plaintiff, you are named as the defendant, and now you have a lawsuit that is against you, and you have to defend that lawsuit or not sometimes. So having a foreclosure filed against you is a civil lawsuit, just like any other lawsuit. Plaintiff, defendant, that's a foreclosure lawsuit. It just happens to be related to real property.
Okay, so why would you want to defend this foreclosure action if you intend on walking away from the property anyway?
Because you have to walk away from the property the correct way. You can't just throw the keys in the air and say, I'm leaving, because you are still on the title to the property until the title transfers to some other entity, whether it be back to your lender or to a purchaser. You still own the property, so you're still responsible for the homeowners association fees if you have them, but also if the grass isn't cut, then the local municipality can start dinging you for fines, and you are responsible for those fines, or God forbid, if something happens on your property, you're liable for that, and you could be sued for something that happens on your property. So you don't want to just walk away if it's your intention to leave and a foreclosure action is filed against you. You've got to do it the proper way. You were a responsible homeowner while you had the house. You've got to be a responsible homeowner when you're exiting the property, and that is, you're going to do a short sale, you're going to ask for a consent judgment from the lender saying, look, I won't fight the foreclosure, I will agree to let you put this property up for auction. But you've got to do everything right until the title is transferred to someone else.
Look, it's no secret this has been a huge problem, not only in the Tampa Bay area, but all across this country.
Yep.
Can you actually win one of these defenses against this?
Well, once in a while, someone does win, and that's why you see it in the newspaper. And unfortunately, I think that gives a lot of people a false sense that, yes, of course you can win against a lender. It's very hard to do. I mean, if you default on your mortgage, you've defaulted on an IOU, you've breached a contract, it's very hard to then, overcome that. But
what are the terms? I mean, give us a scenario of when you do win. How does it work when you can win?
Usually it works because the lender has done such egregious acts against you that a judge says, you know what, I'm going to punish the lender because of what they've done by telling them your case is dismissed with prejudice. You can no longer file another foreclosure action against this party. So think about it. A foreclosure action was filed against you and the judge says it's dismissed and they can never file again. Does that mean you magically own your house? No.
Yeah.
It means that the lender can't sue you again, but the lien on your property, that mortgage, remains there. So if you sell the property, if you want to refinance, you still have the lien on the property.
Okay, if you want to get more information on this, you can contact the law firm of Morris duPont and schedule a free consultation to discuss any issues you're facing with your property.